Chapter 22 brought together one of the most important components of national real estate practice: understanding how to manage risk. Real estate is a profession of high responsibility, and even small errors can create legal, financial, and ethical consequences for a licensee and the brokerage they represent. This chapter connected earlier lessons on agency, disclosure, contracts, and fair housing into one comprehensive framework designed to help you protect clients, yourself, and the public. You learned that risk in real estate is not something to fear, but something to understand and manage through education, preparation, documentation, and awareness of the law. By mastering these concepts, you position yourself as a knowledgeable and trustworthy real estate professional who follows industry standards and safeguards all parties to a transaction. The chapter began by explaining that real estate licensees face risk every day through agency relationships, disclosures, communications, negotiations, contract preparation, advertising, fair housing compliance, and financial handling. Risk exists because clients rely on licensees for expertise and guidance while navigating large financial decisions. This makes transparency, accuracy, and honesty essential professional duties. The two primary sources of risk are the duty to disclose information properly and the duty to carry out agency responsibilities with care, loyalty, diligence, and obedience, while maintaining confidentiality and proper accounting. Failure to perform these duties can result in disciplinary action, civil lawsuits, or even criminal charges. One of the most important concepts in this chapter was the need for written disclosure. You learned that every state requires licensees to disclose their role in a transaction, whether they act as a buyer's agent, seller's agent, dual agent, designated agent, or a facilitator. Written disclosure protects the public by clarifying who represents whom and what fiduciary duties apply. For example, an agent who represents a seller must disclose this relationship to a buyer before giving any real estate services, such as discussing property condition or pricing strategy. Likewise, a buyer's agent must disclose their representation before presenting their buyer's offer to the seller. These disclosures must often be acknowledged with signatures, ensuring there is proof that the consumer received and understood the information. The chapter also emphasized the importance of understanding and fulfilling fiduciary duties. These duties include confidentiality, loyalty, reasonable care, skill, diligence, obedience to lawful instructions, accountability for funds, and full disclosure of material facts. For example, if your seller is willing to accept less than the listing price, you cannot share that information with the buyer because it harms the seller's negotiation position. Conversely, if the seller tells you that the roof leaks during monsoon season, you must disclose this to all buyers, even if the seller prefers you not to. Fulfilling fiduciary duties requires judgment and strict adherence to legal standards. Conflicts of interest were another major risk topic. These occur when an agent's personal interests or financial incentives conflict with their client's best interests. Examples include representing both sides without proper disclosure and consent, referring a preferred inspector in exchange for a referral fee, purchasing a client's property without disclosing personal gain, or pressuring a buyer to proceed so the licensee can receive a commission. You learned that conflicts of interest must always be disclosed in writing, and that the client's interests always come before the agent's personal interests. Confidentiality continues long after a transaction closes. This chapter reinforced that confidential information includes a client's financial situation, personal motivations, and any information not publicly available. For example, if your buyer says they must relocate quickly due to divorce, that information is confidential and cannot be shared. However, information found in public records, such as square footage, assessed value, or liens, is not confidential because it is accessible to everyone. Property disclosures are another major area of risk. Sellers are legally required to disclose material defects, and licensees must ensure that required forms are completed accurately. Examples of material defects include previous water damage, active roof leaks, mold, septic failures, or foundation cracking. You learn that failure to disclose known material facts can lead to both civil liability and criminal fraud. Additionally, federal law requires lead-based paint disclosures for properties built before 1978. Errors in these forms can result in significant fines, triple damages, and potential lawsuits. Another central topic in this chapter was the listing and selling process. Licensees must verify ownership, property condition, and seller authority to avoid errors. For example, a licensee who lists a property without confirming whether the co-owner also agrees to the listing could face legal issues if the unauthorized party later objects. You learned that proper due diligence and verification prevent disputes and protect clients. Contracting risk was another key point. The statute of frauds requires real estate contracts to be in writing. Errors such as missing signatures, incorrect dates, forgotten addenda, or omitted contingencies may result in unenforceable contracts. You learn the importance of using attorney-prepared standard forms, double-checking entries, stating all inclusions and exclusions clearly, and tracking contingency timelines carefully. For example, if the inspection period ends in 10 days and the buyer submits repair request late, the seller may refuse to respond, and the buyer may lose important protections. The chapter also explored fair housing risk. Licensees must avoid discriminatory statements, advertising, or actions based on protected classes. Examples include refusing to show a property to a family with children, answering a buyer's question about the racial makeup of a neighborhood, or advertising a home as perfect for a young couple. Fair housing rules require agents to describe properties, not people. Another major topic was antitrust law. Licensees must not discuss commission rates with other brokerages, engage in price fixing, boycott competitors, or attempt to monopolize services. Even casual conversation about commission amounts can be interpreted as collusion. The Sherman Antitrust Act, Clayton Act, and Federal Trade Commission Act regulate these behaviors and impose severe penalties for violations. Rules and regulations were highlighted as a foundation of compliance. You learned that failure to renew a license, maintain E&O insurance, or comply with state regulations may result in suspension or revocation. Licensees must present every offer, handle earnest money properly, and provide signed copies of documents to clients. Violations lead to discipline from the State Real Estate Commission, civil penalties, lawsuits, and possibly criminal charges. Misrepresentation was heavily discussed as well. Unintentional misrepresentation occurs when an agent makes a mistake or communicates inaccurate information. Examples include incorrectly stating square footage, exaggerating school quality, or mistakenly assuring a buyer that a septic system is in working condition. Intentional misrepresentation, also known as fraud, occurs when a licensee knowingly lies or conceals information. Fraud carries criminal consequences, including fines and imprisonment. You also studied risk associated with recommending service providers. A licensee should provide multiple provider options and avoid steering clients to a single vendor, especially if the agent has a personal relationship with that vendor. This prevents accusations that the agent benefited financially or influenced the client's decision. Financing and closing risks were another important area. Transactions can fail when buyers are improperly qualified or misunderstand financing terms. Licensees should encourage pre-qualification, explain closing costs, and guide clients toward reputable lenders. They must avoid offering legal or financial advice and instead provide general information, referring clients to experts for details. A significant compliance area is RESPA, which prohibits kickbacks, referral fees, and unearned fees. RESPA requires lenders to provide the loan estimate and closing disclosure within specified timeframes. Licensees may not accept compensation for referring clients to appraisers, title companies, inspectors, surveyors, or attorneys. Violating RESPI can result in large fines and criminal penalties. Finally, the chapter addressed trust fund handling and the dangers of commingling and conversion. Brokers must deposit earnest money into properly designated trust accounts, keep accurate records, and never mix business funds with client funds. Conversion, or using client money for personal purposes, is one of the fastest ways to lose a real estate license permanently. Review discussion. Why does agency disclosure matter in every real estate transaction? Disclosure clarifies roles and prevents misunderstandings. Clients must know who represents whom and what duties apply so they can make informed decisions. Without disclosure, an agent could unintentionally mislead a party about their loyalty or obligations. Why is documentation essential in risk management? Documentation preserves a written record of actions, advice, agreements, and disclosures. It protects both clients and agents by providing proof of what occurred and helps resolve disputes quickly and accurately. How do conflicts of interest arise in real estate practice? Conflicts occur when an agent's personal or financial interests clash with a client's best interests. Examples include representing both sides without disclosure, receiving referral fees without explanation, or buying a client's property without proper notice. What makes misrepresentation such a serious risk? Misrepresentation damages trust and may result in lawsuits, disciplinary action, or criminal charges. Real estate professionals are held to a high standard because consumers rely on their knowledge and advice. Closing remarks. Chapter 22 solidified the foundation of professional responsibility in real estate. It showed that success in this industry is not just about selling homes, but about practicing with integrity, accountability, and legal compliance. By understanding agency duties, proper documentation, disclosure requirements, fair housing, antitrust laws, contracting standards, finance protocols, and trust fund rules, you minimize risk and build a reputation grounded in professionalism and ethical service. These concepts not only protect your license, but help you serve the public with confidence and clarity.